This morning's arguments off with Younker versus Hayes, case number 29010. Ms. Hayes did not file a brief. Attorney Burke is here for Mr. Younker. So you'll have 15 minutes for your argument, Attorney Burke. And we've read the briefs and are ready to proceed if you are.
Thank you, Your Honor. If it pleases the court, this is deja vu. Once again, we're in a very bizarre situation here where I'm arguing against an empty chair and I seem to lose. This court, when we were here last time, by way of a little bit of background, when the original magistrate's decision came down, I appealed it timely, and 7-8 months later, the trial court issued its decision, went up on appeal, and the court's obviously familiar with its own decision, and it ended with that the court reversed and remanded for proceedings. There were no proceedings. I wouldn't say that the ink hadn't yet dried on the Court of Appeals decision, but 3 weeks later, I'm waiting, and I get an announcement. I'm figuring it's either a status conference or a new hearing date, and instead it's a new decision where the trial court had basically, after this court had said that the rationale for the original magistrate's decision as affirmed by the trial court was wrong on the law, the trial court took it upon itself to still, because it thought as a matter of law that there were no damages, and so the second time around it just issued a very curt decision saying that the evidence was hearsay, and again entered judgment for no damages. This notwithstanding the fact that the magistrate had originally found that the fair market value of the PSL was more than the $4,000 that was the agreed upon price in the contract. I don't know what to say. I guess, first of all, I this morning looked through the original magistrate decision and the original judgment of the trial court, and the word hearsay doesn't appear anywhere in those decisions. At the hearing, in front of the magistrate, there was obviously no objection by an opponent, but the magistrate gave no indication at the hearing that this evidence would be rejected as hearsay. I dispute that it's hearsay, but at the very least, in fact, there's case law that says when you have a damages hearing on a default judgment, that hearsay and the like is not necessarily a problem, and there's a good rationale for that. The whole idea of the hearsay evidence being a problem is the opponent is deprived of an opportunity to cross-examine the declarant and get to the truth that way. Well, there is no cross-examination in a damages hearing in the first place. Beyond that, the decision by the magistrate, the finding by the magistrate was that she rejected the evidence as to the $44,000 in damages fair market value because, not because of hearsay, but because, I can quote from the court, or excuse me, the magistrate, that, this is the magistrate's decision, that it wasn't competent, credible evidence of the fair market value
Didn't they apply the test in, I think it was Northern Financial, what a willing person, what a person who's not under duress is willing to sell it at?
Absolutely, Your Honor, and this court reversed that. This is the magistrate's decision found on page 3 of the decision that the basis for finding that there was no damages was because of the fact that plaintiff, quote, was unwilling to pay more than $4,000 for the PSLs after Hayes discovered her mistake, i.e. that they were worth more than that. That was the rationale for the magistrate to deny damages on, and it even cites right after that Northern Financial Corporation, which is, I think, fundamental laws to fair market value. This court addressed it and found it applicable. So basically, there was never a dispute that the PSL was worth more than the $4,000 contract price as a matter of law or as a matter of fact in the magistrate's opinion. And in fact, it was because precisely that it was worth more than that, but that my client had refused to pay more than the contract price, that's why there wasn't competent evidence as to that the PSL was worth more, which is kind of a non sequitur.
Counsel,
Yes, sir.
but nonetheless, it is the plaintiff's burden of default to show damages, to prove damages. And if the court is right that you can't just rely on websites, how can we reverse that?
Well, first of all, Your Honor, the question I think initially is this court looking at the decision of the trial judge on remand, what the standard for that is. Is it against the manifest way of the evidence or a de novo review by this court? And I say that because there is cases that I've cited that say basically on default judgments, there's a split of authority as to what the standard of review is. But where the trial court makes this finding and says no damages without having the opportunity to view the witnesses or anything else, then essentially it's saying it as a matter of law. It'd be different if the trial court, if this had been a trial to the court, and the trial court had made its own determination and evaluation as to the credibility of a witness. That was never done here. That was done by the magistrate, and the magistrate basically made no finding that the witness was not credible, made no finding either in the proceeding or in the decision that there was a problem with hearsay. So we go in and present the evidence. It's undisputed that the PSLs, as the magistrate noted, the PSL was worth more, and that's why the defendant, non-appearing defendant, reneged on the contract, because it was undisputed that the evidence was that it was worth more. So first of all, there's no dispute that there weren't damages. It's a question of the amount of damages, not the existence of damages.
Counsel, I also have a question in regard to our last opinion that we wrote that you mentioned. And the third assignment of error is the trial court committed prejudicial error as a matter of law in adopting the magistrate's decision refusing to award damages against Ms. Hayes for breach of contract. That's what you originally raised. And then you argued that the trial court erred in adopting the magistrate's decision, which excluded the prices he obtained from the internet websites as constituting hearsay. And then we say we don't reach the merits of this argument because Mr. Younker did not raise this issue in his objections to the magistrate's decision, so it's forfeited.
Your Honor, I would say, I said that in that brief because it says incompetent evidence. I went back and read the decision, and the trial court's original decision does not speak in terms of disallowance for hearsay. In fact, the trial court's decision adopts the magistrate's decision on the Northern Financial, that there were no damages based on the Northern Financial rationale, which is as a matter of law. And so when this court then remands it for further proceedings, at that point in time, I mean, it's like I'm at a default judgment hearing on damages where there's no objection that I can then say, okay, and put another question to the witness to overcome that as to other evidence or whatever. It's not stated anywhere in the magistrate's decision that the magistrate is disallowing and finding no damages because of, quote, hearsay evidence. And by the way, I cite a slew of cases as to the context of how do you prove damages in a case like this, where it's not like you go to the New York Times or the Wall Street Journal and see what the stock market is for a specific price. The only way, as a practical matter, the only way he was able to obtain this PSL from the defendant was because he had been buying the tickets from her for a number of years and she wanted to unload the PSL. But as a practical matter, the only market that you can actually purchase PSLs from is through these postings by the Browns and others as to, okay, you want seats in this area, this area, this area, and here are the asking prices. So I would submit that this is not prohibited by hearsay rules, and in fact, it's not only the most reliable way, it's, as a practical matter, the only way to determine it.
The court called them anonymous postings.
I'm not sure they're anonymous. They had the identification, you know, when you see the posting, you go ahead and do it, and I believe more of them was under the Cleveland Browns auspices, where the Browns have a site as well where, you know, you put your posting on, identifying the seats, and then you go from there, and then the Browns. And the irony in this case was it's when she went, because this was a personal transaction, when she went to the Browns to get them to do the paperwork so that it would reflect he was the new owner. And virtually every seat in there that has a PSL, the Browns have a record as to who the owner is, and when you sell it, you then have to go and submit the proper paperwork to reflect who the new owner is. In this case, that's how this whole dispute developed, is when she went to submit the record to the Browns to reflect that he would be the new owner of these seats, or this PSL. The Browns said, what are you doing? You know, you're selling it for that. It's worth far more than that. So in the sense of this is just like you're going on online and you might have some hacker from Bulgaria or something who is not who they purport to be. In this case, the Browns themselves have a record. And if we'd gone for another status conference or something, or even in front of the magistrate, that information is available because the Browns keep track of who is the owner and what the asking price is. And so in the first instance, I would submit that this is not hearsay. This is about the only credible evidence that you can use to establish what the asking price is. Because it's not like you can go to a ticket window and see a posting, oh, this football game is $5 for a high school football game. You don't have that here. We're not even talking tickets, we're talking PSLs. But I guess more fundamentally is, the word hearsay never comes up in the proceeding, in the decision, in the trial court's judgment. This court then reverses and remands for proceedings, and then it's like, oh, well, okay, I'm going to totally, the trial court says, I'm going to totally change course here. Before we said there were no damages because of Northern Financial, as a matter of law. I'm now going to go back, instead of having another hearing, I would equate it a little bit to having this court remand on a jury trial. And say remand for a new trial or remand for new proceedings. And typically in those situations, you have a new trial unless there's somebody maybe makes a motion for summary judgment on another basis. But it's not just 3 weeks after this court issues its decision that the trial court then issues a new opinion that basically changes course to 100%, comes up with a totally new basis for the decision. Because if you read the original trial court decision, it's quotes the magistrate, quotes Northern Financial, and says there are no damages here. This isn't competent evidence.
Well, when we remanded it, didn't we only remand it just by saying that the only real error was that the trial court applied mutual mistake because it was a default proceeding and the court couldn't raise its own defenses?
Your Honor, I guess maybe I didn't quite read the decision that way because I read it in the court's opinion that fair market value is not determined by, in a case like this, you can't, otherwise you never have any contractual damages. So the mutual mistake, I would submit that a corollary of that is that this court in its decision said your whole framework for evaluating damages in this case is wrong because the contract price is not the fair market value here. So I think we're talking two corollaries there, whether we call it mutual mistake of fact. Interwoven in that was this whole notion that if you and I have a contract with a price, that by definition is the true fair market value. And if that analysis were correct, you could never have damages by reason of the failure of one or the other party to go through with the purchase transaction. So I think that those two are one and the same in the sense of the mutual mistake of fact here was actually a mistake of law by the court in its analysis as to what is damages, what is fair market value in the context that we have here. So I understand what the court is asking me, but I would submit the trial court's original decision and this court's own opinion address this whole notion of what is fair market value, and says Northern has no application within the context of this case.
And with that, you are 15 minutes has expired. So we want to thank you for your presentation. We'll take the matter under advisement and issue a decision. The courts will mail a copy of the decision to you the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Thank you again for your presentation.
Thank you.